So we're going to be talking about, we can't cover every law, but we've included the ones that we feel that are going to expose you to the highest liability and others that you may be unaware of. So we're going to start with the equal pay for equal work. There's some great embedded links in here. We're just going to do the high level. There's two parts to this law. One is prohibits wage discrimination based on sex, including gender identity alone, and with another protected class. Also, it requires transparency in pay and opportunities for promotion and advancement. The four high-level things that are in this law are: you cannot seek a wage rate history of a prospective employee or rely on the wage history to determine a wage rate. So what that means is if you have a current job application and you have the section where they say prior jobs and you have a section with a wage rate, you need to remove that immediately. There's only 6 permissible factors for pay differences. There's seniority, merit, quantity quality, geographic location, education, training or experience, and travel. The third and fourth are really very important. If an employer has an open position, they have to make reasonable efforts to announce and post all opportunities to all current employees. It also needs to include a wage and information on benefits. Also, the law says that in each posting, so that includes external job postings. So if you post on Indeed, you need to put a wage range and a general description of all benefits and other compensations to be offered to the hire applicant. We really strongly suggest all employers, at the minimum, really look for pay disparities. But the best thing would be is to develop a thorough compensation plan. I have had comments from people that if you do look through Indeed, there are some Colorado jobs that don't have the wage on there, and they are in violation, and they've tried to do some marketing on this, the Denver Business Journal. So this is my personal feeling that I suspect that once they've kind of done a marketing piece, that they are going to start going out there and issuing fines to ensure that people are up to speed on it. So, oops. Okay, so we're on Ban the Box. This was passed in September 1st of 2019. Now, employers with 11 or more employees were subject to this act. But in 17 weeks, all employers are going to be subject to this act, September 1st. And what it prohibits is stating in an advertisement or an application that a person with a criminal history may not apply. Inquiring into the applicant's criminal history on the initial application. So once again, pull out that application, remove the wage history, remove any questions about criminal history, and requiring the disclosure of an applicant's criminal history on the initial application for a position of employment. If you do background checks, now obviously there's safety sensitive positions, but you have to have made a job offer to be able to actually initiate the background check, or at least one of the final candidates. This next one's a big deal. A lot of people, it's called obviously employment at will. Most of you understand that. What that means is in the absence of a contract, neither the employer nor the employee is required to give notice or advance notice of termination or resignation. Additionally, neither the employer nor the employee is required to give a reason for the separation. Now, we hear from employers from time to time, and they'll make them statement, I can fire them. This is an at-will state. This is becoming more and more a dangerous mindset. And what you're going to see on just the laws that we have today, which aren't all of them, that you really need to ensure that your termination is for a reason, it's solid, it's lawful, and you have documentation. When it comes to employment law, whoever has the most accurate documentation and factual documentation has the best protection. We're talking about records retention in the equal pay for equal work. it does state that an employer shall keep records of job descriptions and wage history for each employee for the duration of the employment, plus 2 years after the end of the employment, in order to determine if there's a pattern of wage discrimination. There's probably three steps that you want to take as soon as possible. You need an accurate, very detailed, I shouldn't say very detailed, but job description, and especially including physical abilities. We're seeing a lot of ADA challenges. You want to update your employee handbook, and you really want to look at your compensation to review for any kind of disparities. So now I'm going to turn it over to Jennifer, and she is going to talk about, it's called CADA, and it's the Colorado Anti-Discrimination Act.
Thanks, Becky. The Colorado Anti-Discrimination Act, oops, we skipped a slide.
Sorry.
The Colorado Anti-Discrimination Act is basically the Colorado state equivalent of the federal Title VII of the Civil Rights Act, as well as the ADA, the Age Discrimination and Employment Act. It's basically Colorado state law that encompasses all of the federally protected classes for purposes of unlawful discrimination. The Colorado Anti-Discrimination Act was last amended in to be effective in 2015. At that time, it allowed the additional recovery of punitive damages against employers, compensatory damages for emotional pain and suffering, mental anguish, loss of enjoyment of life, inconvenience, and other losses not directly relating to or consisting of money or economic damages. It also allowed the recovery of attorney's fees, which were previously not recoverable under a CADA claim. And then it also changed or eliminated the maximum age in Colorado for employees to make an age discrimination claim. Before the 2015 amendments in Colorado, you could only make a state law age discrimination claim if you were between the ages of 40 and 70. So after 2015, Colorado eliminated the maximum age, which was 70 before then. There is a new bill that was introduced earlier this year in 2021. It's Senate Bill 21-176, and it's called Protecting Opportunities and Workers' Rights Act. So it's POWR is the acronym. And that, if it passes, will impose sweeping changes to this law that will be effective at a future date. But the proposal does include changes, and we don't know what if any is going to pass yet, but the changes that are proposed would be to cover independent contractors under the state law, to prohibit confidential settlements of harassment or discrimination claims, to eliminate the administrative prerequisite to filing suit, which is normally claimants have to file an administrative charge with a state or federal agency before they have a right to sue, but these proposed amendments would eliminate that administrative step. And then it would expand liability and limit certain defenses. So that's pending. Stay tuned. We don't know what's going to happen with that. Again, it was just introduced in 2021. So we'll move on to the next slide. This next slide talks about something that's been both pushed on the federal level as well as on the state level. So here in Colorado, we do have a passed law. It was passed in 2020, and it was signed in March of 2020 by the governor. And it is to protect individuals mainly on the basis of race, who have a certain hair texture, hair type, or protective hairstyle. So it's just it's kind of an extension of the Colorado Anti-Discrimination Act, specifically prohibiting conduct by employers that is based on someone's hairstyle, and you should just be aware of that. The next slide is focusing on social media protections. We have a law on the books in Colorado for both public and private employers. So public employers are government entities, school districts, municipalities, and private employers are probably mostly everyone who's on the phone call or on the webinar today. And an employer cannot access an employee's or applicant's personal social media accounts. So what that means is, obviously for applicants or even employees, employers can see what's available publicly. If any employee or applicant has a Twitter, Facebook, I guess TikTok are the new ones, and Instagram, if they have any of those accounts that are public, then that is not prohibited. It's if the employer has a means of accessing those accounts that are set to private. For example, if an employer, recruiter, or employee befriends an applicant or employee on social media for purposes of gaining access to their private content, that would be subject to this law.
Okay, now we're going to move on, and Teresa will have.
Good morning, everybody. So I'm going to talk about pregnancy and childbirth accommodations. It's referred to as the Pregnant Workers Fairness Act. This actually became a law in Colorado in August of 2016. It does affect all employers in Colorado. And what the law states is that it is discriminatory or an unfair employment practice if an employer fails to provide reasonable accommodations to an applicant or an employee who is pregnant, physically recovering from childbirth, or any other related condition to that pregnancy. What some of those reasonable accommodations may be are frequent or longer break periods, frequent restroom, food, and water breaks, modified equipment or seating. So if they're in a standing position, maybe they need to sit for that work time. Obviously, any lifting limitations. Even temporary transfer to a less strenuous or hazardous position, if available. Doesn't necessarily mean that you have to make one available. And then light duty if available. So a reasonable accommodation must not pose an undue hardship on the employer. The following factors are considered in determining whether it would be considered an undue hardship for the employer, and that is the nature and the cost of the accommodation, the overall financial resources of the employer, the size of the employer's business, as well as the accommodation's effect on expenses and resources, on the operations of the employer. So this law must be posted in a conspicuous area of the workplace. It is actually included on the Colorado labor law poster, that all-in-one poster. So if you have that up, then you're fine. Otherwise, you can go to the Colorado Department of Labor website and print that out and make sure that you post that. Employers must also provide a written notice. So if you do have a handbook, make sure that that's in your handbook. If not, you need to present that to the employee to go into their personnel file. The next one is lactation policy. This actually was put into place quite a few years ago. 2008 is what I found. And what it does is it requires public and private employers who have one or more employee to provide a reasonable unpaid break, or permit an employee to use their paid break time, meal time, um, each day to allow the employee to express breast milk. And this is for up to 2 years after the child's birth. So it does require an employer to make reasonable efforts to provide a room, or other location in close proximity to the work area, other than a toilet stall, where an employee can express breast milk um, in private. Okay, next slide. Youth labor laws. Um, a minor is any person under the age of 18. There is an exception, and that is a person who has received a high school diploma or a passing score on a GED examination. And what I have found is if you just Google Colorado Youth Law Fact Sheet, you're going to get this fact sheet that is really easy to read. Um, it was last updated in August of 2016, but what it does is it breaks down by age, what the permissible occupations would be by age. It discusses work permits, hazardous work that may be prohibited for the certain age, and work hour restrictions as well. All right, so now the big one. We could literally spend the entire presentation on comps order, but we're just going to highlight some of the key areas of the comps order 37. Comps order 36 actually became effective in Colorado March 16th of 2020. Most people kind of forgot about it because that's right when COVID hit. So we had other priorities to focus on at that time. But that's actually when it became a law effective in Colorado in 2020. They have made updates to Comps Order 36 and into Comps 37, which those were effective on January 1st of 2021. So the comps order actually does not apply to states or its agencies and entities, counties and cities, municipal corporation, even those quasi-municipal corporations, special districts, and so on, school districts, or irrigation, reservoir, or drainage conservation companies or districts. I'm going to talk a little bit about what the posting requirements are for Comps Order 37. So employers must display this poster. There's a Comps Order poster. I think, yeah, we have it on on the screen there. They must display this poster where employees can easily read it during the workday. If a physical posting is impractical, then you must provide copies of the poster or the comps order to each employee in the first month of work. Employers must provide this poster upon request and include a copy with any written handbook or policies. So if you do have a handbook, then you need to make sure that you include the poster in the handbook as well as in the acknowledgement portion of your handbook. If you have employees with limited English language, maybe the majority of your work staff is Spanish, you need to have a correlating poster to that language. I think they're up to like 14 different languages on the Colorado Department of Labor. So just go in there and under the search type in Comps 37 poster and it'll bring all those up for you and you can just print those out. One of the bigger areas is meal and rest periods. So the comp order states that meal periods are 30 minutes of uninterrupted and duty-free for employees that have shifts of over 5 hours. The employees must be completely relieved of all duties and allowed to pursue personal activities. Um, if work makes that uninterrupted meal period impractical, eating an on-duty meal must be permitted, but that time needs to be paid. To the extent practical, those meal periods must be at least 1 hour after the starting shift and 1 hour before the shift ends. Rest periods. We have heard from a couple of different employment attorneys that they're really starting to see a lot of lawsuits come in with wage and hour claims for rest periods under the comps order. Rest periods are 10 minutes of paid rest period for every 4 hours of work. The rest period doesn't need to be off-site, but must include work and should be in the middle, if practical, of that 4 hour shift. The employer can do 2 5-minute rest periods if that works, better for you. But the employees and the employers need to agree on that 2 5-minute rest periods. It can get a little tricky, and you'll understand why as I kind of start talking about what you should do as far as tracking those rest periods. So employers that do not authorize or permit rest periods must pay extra for the work time that would have been the rest periods. This is because the rest period requires 10 minutes of pay without work being performed. So work during a rest period is considered additional work for which additional pay is not provided. So you have to pay an additional 10 minutes of time if your employees do not take those 10-minute rest periods. From what we hear, it is probably best that if there's any way that you can track those rest periods, whether it's just, a sheet of paper that the employee initials saying that they took that rest period, that's a great way of doing it. Another way would be if you have an electronic clock in, clock out system. They can clock out and clock back in. You just need to obviously make sure that you go back and make sure that that time is actually paid. There may be some systems out there that that you can do that without having to go back and make sure that time is paid. But it is really important that you are doing your best to ensure that when the employees do take those breaks, that you can record them in some way. And if they're not taking those breaks, you need to make sure that you're paying them for that additional time. Talking about time worked under the comps order, and that is defined as requiring or permitting employees to be on the employer's premises, on duty, or at a prescribed workplace, and that's for over 1 minute. Okay, so if your employees are working, say they're at home and you're texting them or calling them or emailing them, if it takes them over a minute, and this is for hourly employees or non-exempt, if it takes them over a minute for them to respond to whatever request you have, then that time they need to be compensated for that time. It also includes putting on or removing work clothes or gear. So if you have uniforms that, perhaps are laundered by the company and the employee has to come in and change into that uniform, then that time should be compensated as well. Cleanup, setup, or other off the clock duty, awaiting assignments at work, or receiving or sharing work related information, Security and safety screening, if you're doing that, then that time needs to be compensated. Clocking and checking in or out, or waiting for any of what I just mentioned, the tasks above. Also, travel for the employer benefit is time worked. That does not typically include that normal home to work travel. I also want to talk a little bit about exempt employee salary thresholds. With the comps order, they have identified salary thresholds that need to be met for your exempt employees. And for starting January of 21 through this year, that salary needs to be at least $778.85 per week, or $40,500 per year. Now that's going to go up starting January of 2022 to $865.38 per week, or $45,000 per year. So you need to keep that in mind and budget appropriately. Additionally, to meeting the salary threshold, an exempt employee's position duties must meet the duty basis test, in addition to that salary. All right, so I think I'm done for now.
Great, awesome. So Jennifer's next.
All right. So for our next slide, this topic deals with permissible deductions from wages by employers. And it lists, 5 bullets where deductions from wages are permissible. Basically, tax withholdings, Social Security, for Social Security, Medicare, Colorado state law, any kind of mandated, tax withholding that is required by local, state, or federal law is permissible. Deductions by written agreement are permissible, and this is where I see a lot of employers in Colorado get into trouble. Maybe an employer provides a cash advance to an employee and then seeks to recoup that cash advance in later paychecks. Just keep in mind, under Colorado law, you need to get that in writing. If you're going to give a cash advance, make sure you get a written agreement back that says that you can make a deduction to recoup that advance later on. Otherwise, as an employer, you can be exposed to the employee claiming an unlawful deduction. And given the hyper technicality of wage and hour law, you could lose that claim if you don't have a written agreement, even though it doesn't seem equitable. The other deductions would be if you need to recover the replacement cost of an item or due to damage or theft. But again, here it's very specific. The law is, and we don't have the full text of the law on this slide, obviously, but if you want to recover the replacement cost of something, you actually need to, like for a theft, which is a crime, you actually need to file a police report to indicate that you believe a theft occurred. So an employer can't just make this deduction without doing all of the required steps by statute. So just the good rule of thumb is, if you as an employer are planning on making any deductions to an employee's wages, really important to consult with your HR professional or an employment attorney before you go ahead and make those deductions, because you can be subject to claims under the Colorado wage and hour law, which are not fun claims to have to defend. And again, they're hyper technical. And another area that I see a lot of issues come up is where employers want to fine somebody for maybe not getting a report in on time, or not complying with the policy. And again, that would be an impermissible deduction, you really can't even have that as an agreement, because that's just not a lawful way to discipline workers, to make a deduction from wages. And then lastly, another important item would be to remember any deduction from a wage cannot reduce the wage to below minimum wage. So basically, like if you have an agreement for a cash advance recoupment and you're going to recoup it over the next few paychecks, it's really important to make sure that the paychecks where you are taking the money back out do not reduce the employee's pay to below minimum wage. So basically, if they have a paycheck of $1,000 to them, you can't take the whole $1,000 to recoup what they owe you. You have to make sure however many hours they worked, they are paid at minimum wage, and then you can take the rest as the recoupment. The next slide, we are just focusing on employer record keeping obligations. So under Colorado law, very specific about when pay periods have to occur. They basically, an employer who has W-2 employees needs to have regular pay periods that are at least once a month. Most people have it either bi-weekly or semi-monthly, which are kind of confusing terms, but bi-weekly means that the employer is paying every 2 weeks, and semi-monthly means an employer is paying twice a month. So you can imagine where we have months with 31 days and 30 days, that sometimes bi-weekly means people might get 3 paychecks in a particularly long month, as opposed to semi-monthly, which means employees are getting paid, say, on the 1st and the 15th every single month. Just make sure it's no longer than 30 days for your regular pay periods. There are also specifics about when paydays have to occur. They can't be longer than 10 days following the end of the pay period. And then there are record retention requirements under Colorado law. Payroll records have to be retained for at least 3 years after the wages or comp were due. And there's specifics about what those records have to include. I'm seeing a lot these days of the fines under the record keeping laws come up in wage and hour claims that are brought before the Colorado Department of Labor that are under $7,500. Currently, employees, aggrieved employees, can bring wage and hour claims before the agency, the Colorado Department of Labor, as long as the amount of wages they're seeking is under $7,500. So what I'm seeing is when those claims are successful by the employees before the agency is awarding the wages owed plus the penalties under the wage statute, which are 125% of the wages owed. So if an employee is found to be owed $500 in wages, they will get an automatic penalty award of 125% of that. So an additional, what is that, $600 and some dollars in penalties. And then the division will also assess fines if they feel like the employer's records are not good enough. So really, really important to ensure that employers are maintaining these records and tracking hours. That's also an area that I see a lot of small employers dealing with wage and hour claims on, where they say, well, I trust my employees and they know they're only supposed to work from 9 to 5 or whatever, but then something goes sideways in the relationship and the employee says, no, I worked all this overtime, and brings a claim, and the employer doesn't have time records that are maintained by the employee to verify their hours. So really, really important for employers to understand their record keeping obligations and make sure they do those. Sorry, my dog decided to chime in there. Okay, the next slide that we have is what I'm sure most of you are aware of, and struggling to comply with since it was passed in July of last year, the Healthy Families and Workplaces Act in Colorado. Of late, we have seen the Colorado Department of Labor issue some new information sheets that provide that the COVID-19 paid leave has been extended, and that all employers, regardless of size, are required to provide the COVID sick leave. So there are some new Colorado Department of Labor rules that are available on their website, actually, and I would encourage everybody to go there. You can get what are called interpretive notice and formal opinions that are provided by the Colorado Department of Labor. And so if you go to the website for the Colorado Department of Labor, just Google it, or it's cdle.colorado.gov, then, or you can Google it. You can go to their labor laws and stats page, and then you would find their interpretive notice and formal opinions. They're called infos, and they're published guidance. And so I would really encourage you to go there, because the Healthy Families and Workplaces Act has a lot of nuances, a lot of particularities, and it's kind of impossible for us to go over all of those on a webinar for a few minutes. And so those info guides are really going to provide a lot of assistance. And there's two new ones that were just updated in April. So basically just be aware that all employers, regardless of size, have to provide the paid leave under the HFWA for a COVID-related absence. Otherwise, employers have to be at least 15 or more employees to be required this year in 2021 to provide the paid sick leave or other paid leave under the act. And then in 2022, that 15 or more threshold does not apply. So originally it was a graduated act where it said, you know, only large employers have to provide certain types of paid leave. And then in January 1 of 2021, the act said, well, now employers with 15 or more employees have to provide the paid sick and other types of protected leave. And then in 2022, we want all employers in Colorado to provide it. But given that we're still under this emergency public health emergency situation with COVID, and because the governor has still declared we're in a public health emergency, all employers should be aware that they need to provide up to 80 hours of paid leave for employees that have a COVID-19 related absence. And paid leave for this public health emergency is also very specific and challenging for employers, because you can't require documentation for the public health emergency leave. So you can require a return to work certification, but you can't require documentation before the leave is taken, basically. So again, there's very specific rules and nuances. So I think the best resource is to go to the Colorado Department of Labor website and pull those info sheets. Colorado employers should just also be aware of the rules that we have regarding paid vacation, jury duty leave, holidays, and voting time. So in Colorado right now, there is no legal obligation for Colorado employers to provide paid vacation. But if Colorado employers do provide paid vacation, and they provide that it is accrued under a policy or an agreement, then they do have to pay that out currently under Colorado law on separation of employment. There are two cases right now pending in the Colorado Supreme Court that are going to address whether or not Colorado employers can have use it or lose it policies. But we have not seen a decision as of yet, although we're expecting a decision anytime, because those cases have been fully briefed before the Colorado Supreme Court, and there's already been oral argument on those cases, which occurred in November of last year. So we are looking for those decisions to come down anytime, and that'll provide some much needed clarity on whether or not employers can have use it or lose it policies. But for now, if employers do have vacation policies that provide for the accrual of paid vacation, keep in mind that the Department of Labor will enforce their own rules, which say that that has to be paid out on separation from employment. And you could be subject to differing decisions by the courts, because we don't yet have a final decision from the Colorado Supreme Court on it. You can have paid holidays as well, but those don't need to be paid out upon separation from employment, and they're not required under Colorado law. And then this slide also provides just what's required for jury duty and voting time.
Great.
Okay, back to me. Actually, I did want to mention for the HFWA, I know there's a lot of numbers going around out there, but it's actually 16 or more employees for the HFWA paid sick leave beginning January of 21, and then all employers starting January of 22. So volunteer firefighter leave, this actually became enacted in 2008 in Colorado. And what it states is that an employer shall not terminate an employee who is a volunteer firefighter and who fails to report to work because the employee has responded to an emergency summons. If the employee provides the employer with a written statement from either the chief, from the chief of the fire department for that employee's absence. The employer can deduct time lost from the employment caused by a response to an emergency summons from the wages of the employee who is a volunteer firefighter. Another one in Colorado is the lawful off duties activities. Not a lot of people know about this one. It has a nickname. It's called the smoker's law. And what it states is that it's unlawful to discriminate against an employee based on off-duty legal conduct. Okay. Some of those protected activities would be use of tobacco products, alcohol use, and use of all lawful products. However, it does not provide employment protection to those engaged in activities that actually violate a state or federal law. Also, something that's not on the slides, but I wanted to mention is the Colorado military leave. And what it states is that members of the Colorado National Guard, or the U.S. Armed Force Reserves are entitled up to 15 days of unpaid leave per year for training with employment reinstatement rights. Another one is domestic abuse leave law. And for Colorado employers with 50 or more employees, it permits an employee to request or take up to 3 working days of leave from work in any 12-month period. And it's up to the employer to determine whether that's paid or unpaid. If the employee is the victim of domestic abuse, of stalking, sexual assault, or any other crime related to domestic abuse. And just to put out there, this law is going to stay in place even though we have the domestic abuse paid sick leave available through the HFWA law. So this will be in addition to that leave. All right, next slide, Becky. Payment of final wages upon separation. So if the termination of employment is made by the employer, then that requires wages or compensation for labor, service earned, any time vested, and unpaid at the time of such discharge. Those wages are due and payable immediately, except when the employer's accounting unit that is responsible for, drawing of the payroll checks is not regularly scheduled to be operational. In those situations, then the wages due to the separated employee shall be made available to the employee no later than 6 hours after the start of such employer's accounting unit's next regular workday, as well as if the accounting unit is located off the work site, the employer shall deliver the check for wages due to the separated employee no later than 24 hours after the start of the employer's accounting unit's next regular workday to one of the following locations. And that can be either to the work site, to the employer's local office, or mailing it to the employee's last known mailing address. All this information you can find on the Colorado Department of Labor website as well. So for those employees that voluntarily quit or resign, then they would just be paid out their wages and compensation up at the next regular payday. And they can be paid out by check, they can be paid out by cash, or even, if you have direct deposit set up, then they can be paid out by direct deposit as well.
Great. Thanks so much, Teresa and Jennifer. Now we're going to talk about some coming soon laws. The big one is going to be the Colorado Paid and Medical Leave Insurance Program. The payroll taxes are going to begin in 1/1/23, and the program is going to be effective 1/1/24. They are setting up an entire separate division. So there's going to be a lot of information forthcoming. This is going to provide up to 16 weeks of insurance benefits eligible to employees for health and safety reasons. Towards the end of the webinar here, we're going to talk a little bit about conflict of federal law and Colorado law. There has been talk at the federal level that they are going to strive for a similar program like this federally. So we'll talk about that at the end. The next slide, this one passed us by somehow, but there is a law that was passed in 2020 called the Colorado Secure Savings Program. It is going to be a state facilitated automatic enrollment workplace savings program for all Colorado with 5 or more employees. So what the intent of this law is for small employers that are unable to provide any type of IRA, 401k, simple plan, that the state's going to create a program where employees can invest. Now, where the employers come in is there's going to be administration responsibility and notification responsibilities on the employer. The employee can contribute up to 5%. There's no employer match. Now, if employers do have some sort of qualified program, they are exempt. They have not said, unless Jennifer, you have any updated information, we've seen estimates that it will start by the end of 2021, but I haven't seen any specific date on when this one is going to take effect. So hopefully all of you are signed up for our newsletter, because we do send out breaking news emails when things like this come about. And then the last thing we're going to talk about, and actually I'm going to want Jennifer to jump in here because we haven't had time to really discuss this, but there is a paid leave tax credit, I'm sure you've all heard, for COVID vaccinations. The eligible employers are entitled to tax credits, and we'll make a big disclaimer here. We're not the IRS. You would want to check with your CPA on tax credits for employees who aren't able to work or telework due to COVID, including receiving the COVID vaccine, recovering from an injury, disability, illness, or condition. It's available for employers with less than 500, and then it's up for 10 days. It's funded by the American Rescue Plan, and this qualified time off can take place between April 1st and September 30th. Now, the questions that we're receiving is, since we are under a PHE, as an employer, currently all employers in Colorado have to provide the 80 hours for COVID type related reasons. So we've had employers ask us, can we do the federal program, take the tax credits? I'm going to have Jennifer jump in here, but we did call the Department of Labor. My entire team called the Department of Labor. We got two different answers, but two of the most similar answers is what they provide us is they say, if the federal law satisfies all requirements of the state law, you should be able to utilize the federal law. So Jennifer, I want you to jump in there and see if we have been provided the right information, if that's your understanding.
Well, first I'll say my recommendation would be for any tax related issue would be to consult with a tax professional, just because, we're in employment law. And so the tax laws can be so complicated and overlapped that if you are planning on taking a tax credit against federal taxes like Medicare taxes, which is what this paid leave tax or this paid leave credit provides, that it's a highly complex issue and it does involve multiple different tax laws. So, I would encourage talking with your CPA before you go ahead and take all of these credits. But then secondarily, what you stated, Rebecca, is generally true. The concept that if the federal law, if compliance with the federal law means that you are fully complying with a more restrictive Colorado law, then you can follow the federal law without running afoul of Colorado law, if that makes sense. So basically, usually state law is more restrictive than federal law. And so if you as an employer are complying with the federal law, which allows for credits, and that federal law does not cut against or offer less benefits than a Colorado state law would, then you are generally okay with complying with that federal law and taking those credits. So I hope that helps.
Right.
I'm not a tax expert, so
Yeah.
I just can't speak to the tax issues specifically.
No, that's great. Thanks. And I think also our recommendation would be, if you're going to choose whichever direction you're going to choose, make sure in all of these, when you're paying somebody out, make sure there's clear identifying factors. Make the deduction HFWA, the pay, make the P PHE. Make sure to identify it in your payroll system. So should you be challenged, you can show that you have, paid according to these allotments of time under those specific areas. So I really encourage everybody to look at their payroll and make sure it's very specific and employees understand it. It's, printed on the paycheck as, PHE, HFWA. So. Well, great. Well, that brings us to the end of the webinar. I'm really sorry for the rough beginning there. I apologize. As always, we're going to try to see if we have a few questions. I know we're getting close to 11, but Teresa, do you have some questions we can address right now, or?
Yeah, let's see. one question is, if I'm advertising for entry-level positions starting at minimum wage, do I have to include wages in advertisement? The question is always yes. That's just a requirement of the equal pay for equal work law, that you have to post any wage regardless of what it is. You can post a wage range, but a wage needs to be posted. Any further comments on that, Becky?
Nope, you got it.
Okay. And Jennifer, you might know this one, in talking about the Crown Act. What about hair color?
Hair color doesn't seem to me to be particularly tied to race. If it were a hair color issue that was somehow tied to race, then that would be a protected characteristic. I just can't think of a circumstance, or a hypothetical where hair color would be associated with someone's race.
Okay.
But if it were, then it would be certainly a characteristic that would fall under the Crown Act. But the Crown Act doesn't specifically mention hair color, because I think that's just because it isn't normally tied to the issues.
Okay. Okay. Perfect. Do you have a recommendation on where to get applications that don't have the criminal and wage history? We have sample question or applications. Human Resources Plus does, so just contact us. Do you have to pay the employee if they express breast milk at any other time other than lunch? No, it is unpaid. So if they don't utilize that time during lunch or during their paid breaks, then that would be unpaid. And I think you can limit that time as well. Gosh, it might be, I'm not 100% sure on that, but it might be up to 20 minutes. You can limit that unpaid time. Any comments on that from Jennifer or Becky?
Nope, let's just take one more question and then we'll kind of wrap it
Okay.
up.
And this one might be for Jennifer then. Can the employee decide themselves to not take a lunch? I would certainly suggest that you get that in writing if they don't want to take a lunch, and that they know that they have time available for that lunch. But I don't know if you want to add to that, Jennifer.
Yeah, I mean, I agree. If you are going to, allow an employee to miss lunch from time to time, I would just make sure that that is well documented, and the reasons why. But as a general rule of thumb, I would say it's not wise for an employer to say, oh yeah, sure, you don't have to take a lunch because you want to leave early, or you want to have a schedule such that, you aren't taking a half an hour or an hour paid meal period. The reason I say that is because the Department of Labor is going to really, really scrutinize an employer for that. And where employers get into trouble a lot is where they're basically not complying with the law because of a request by an employee. And so the employer's thinking, oh, I'm being a good employer. I'm being nice. I'm complying or agreeing to the requests of my employees. And that's not a defense, unfortunately, to the technicalities of wage and hour law. So both state and federally, wage and hour law is hyper technical, and there really can't be, these agreements between employers and employees that run afoul of what's required by those laws. And since paid or unpaid meal periods and paid rest breaks are required by law, you really are not going to be, it's not going to be a wise decision to just say, oh, well, my employee didn't want to have to take a daily unpaid meal period because they wanted to leave early, or they didn't want to, they wanted to get in their car to avoid traffic. Where I think it's okay to do it from time to time, I certainly would not encourage doing that on a regular or frequent basis because of the risk of scrutiny from the government over noncompliance. as well as, you know, potential claims that could arise as well.
Okay.
Great. Well, thank you everybody for attending. We really are honored that you attend these webinars and allow us to provide some communication. You will be receiving, as we said, the PowerPoint presentation and the recording. We'd love for you to complete our survey feedback so we can continue to improve and provide valuable information for you. So thank you very much and have a great day.